Hi, welcome to North State Law. My name is Nick Dogle, owner and founder. Today's topic is what is a public letter of concern from the North Carolina Medical Board. So last video we talked about what a private letter of concern from the North Carolina Medical Board is, and that is one step above a dismissal. You can go back and watch that video for more information on that. A public letter of concern is going to be one step above the private letter of concern from the North Carolina Medical Board. So obviously, the process starts with a patient or former patient, or it could be a colleague, it could be somebody in administration. Rarely does it happen, but it could be a competitor or somebody from the general public that sees something that they think that you did that they didn't like. Anyways, they file a complaint. Investigator sends you over their whole investigative summary of what to expect and kind of their outline of how their investigative process works. They eventually do their investigation, which would include an interview with the investigator. That happens about 99% of the time, in my experience at least. And then the investigator shoots it on over to the disciplinary committee with the medical board and one of their attorneys that's assigned to it. They'll look over everything, they come back and say, hey, I think that there's a violation here. I also feel like it might not be very egregious, or there might be a lot of mitigating factors here that we're taking into consideration, and they come back with a recommendation for a public letter of concern. So, public letter of concern is not ideal, but it could be worse. So it's basically like, I don't want to say purgatory because I think that might be a little bit harsh of an explanation, but it's very close to that, if that makes any sense. Essentially, what makes it not ideal is that it's public. So when somebody checks to see if you have a license, it's going to pop up on the board's website. It's not going to be considered discipline, curiously, and unfortunately, it is going to be sent to the National Practitioners Data Bank. So two negatives there, only one positive. The only positive being that it is not considered discipline. Why they decide to do it the way that they're doing, I don't really know, other than the fact that it's just another level of mechanism that they can use, or another tool in their belt that they can use for punishment purposes that will not go straight to like a public reprimand, which is considered discipline. So I think the thought process, and I'm just speculating, but I think the thought process with the medical board was, hey, we don't want to jump straight from a private letter of concern up to a public reprimand and have it be considered discipline and then publish on the website and consider it public. Let's have like something kind of in the middle where, yeah, it's considered public, it's going to be posted, it's going to be sent to the National Practitioner Data Bank, but it's not considered discipline. So my assumption is that's what the process was when they were thinking about it. Again, it's not ideal, but it could be worse, could be a little bit better if you get a public letter of concern. That is something that you can still request a hearing from and say, no, I don't like that. I don't think that I did anything that was egregious enough to warrant a public letter of concern. You can say, hey, I don't want to take that. Until you get to the hearing and have the hearing, you can still negotiate with them. They're pretty good about that. I try to give boards credit where credit's due, and I think the medical board, when they try to negotiate with people, they try to keep an open line of communication. I think they do a good job on that, in my experience at least. So if it's something that you're like, you know what, I think that's fair, I'm going to take that, then at the end of the day, you got to do what's in your best interest. There may or may not be some wiggle room regarding what is contained in that public letter of concern. That really depends on the facts and circumstances, but that's I'm an all options open on the table type of person. So if it's something reasonable, then it's something worth exploring with the other side. If it's not something reasonable, then that's usually not something worth bringing up to the other side. Obviously, those are fact specific and depending on certain circumstances as well. So I hope that kind of explains pretty clearly what a public letter of concern from the North Carolina Medical Board is. You can check out the blogs on my website. They are plentiful, and that is northstatelawfirm.com. You can also check out a lot of other videos that are on my YouTube channel. That's North State Law's YouTube channel. If you can't find what you're looking for in either one of those locations, please give my office a call or a text at 919-521-8810, and we can set you up with a free 15-minute discovery call with a member of my staff. Thank you so much for what you do in taking care of North Carolina. We certainly do appreciate it. You guys have a fantastic day.